Hello everybody, welcome back to Law Hero. My name is Jen and I make videos about the law. More specifically, tonight we're talking about FE1s and I think tonight I am going to do some equity. If you haven't already as well, make sure you follow me on Instagram and make sure you like and subscribe, because this is where all the videos come out, and if you're not subscribed you won't know it. Okay, so the first question involved some charitable trusts. And just to take a step back, when it's a problem question with charitable trusts, lots of people try to get a round peg, a square peg to fit into a round hole. And what I mean by that is they try and push the facts they're given into the Section 3 of the Charities Act 2009 definition. And even though sometimes it may not be a charitable bequest, people always try and make it one. And then if it's not, they'll go, CPRE doctrine, which is also not correct. So let me explain. In this problem question, you have to pay very close attention to the facts, because you can't just assume there's a charitable trust here. They're very special charitable trusts. There's a lot of concern around tax evasion and also people not getting what's due to them under a will. So it's very important that if you are claiming that certain monies have been put aside on trust to benefit a charitable cause, that you're able to prove it. It's not just a fait accompli. So this person was a member of the Irish Sports Association, but that is just mentioned once in this question, you'll notice, okay? So if you're a lifelong member of a sports association, you'd imagine that, okay, if this person did put money aside in their will for sport, it wouldn't be far off how they lived their life while they were alive. An organisation dedicated to the promotion of certain amateur sports. So we already see there's a caveat. Not all sports is looked after by this association. He devoted much of his free time to the activities of the organisation, both as a player and official, for many years of his long life. His love of sport and of the association are reflected in a number of legacies in his will, which are bequeathed to his executor on trust for a number of distinct purposes. Bequest number 1. He directed a sum of 2 million be used by the executor in such manner as he sees fit to promote the playing of football in rural communities. Okay. We don't really, playing football in a rural community, is it charitable? It's sporting for sure. When we think about the Charities Act, we can think to ourselves, okay, what limb would this fall under? So for example, Section 3, a number of areas which are deemed to have charitable purpose. So advancement of community welfare maybe could fall into that. So if we look for gifts for sporting and recreational purposes, they're generally not recognised. And a good case around this was the National Tourism Development Authority v Coughlin, or Colin if you're from Cork, which was a claim for charitable status for a golf course was denied. It was noted that the trust was primarily for the benefit of members only who could afford the green fees. The profits were not distributed to the members but were returned to the business. Okay, but you could argue here that in the rural communities thing here, you could say that is for the benefit of the community. So I would say maybe 50-50 for the first bequest. The second bequest, he directed the sum of 1 million to be used by the executor to ensure the provision of playing fields in Joe's hometown. Again, it's in his town. The playing fields, they are for sport, but you do have to be a member usually of a GA club to play on the field. But if they're in the town, and you would imagine that kids and stuff will play in them, so again, you could argue that they are for the community's benefit, like that he's benefiting the community. The third one, though, is pretty obvious. So it was 100 grand for the purpose of organising a campaign to promote the introduction of legislation to criminalise certain conduct on the pitch, such as remonstrating with referees. That seems to have a political element to it, and we know that that's not allowed. You would have lost marks if you went down through the nature of charitable trust, like if you talked about Rishaw or Macmullen or Compton or any of those. You would see, the thing is as well, if you mentioned CPRE as well, you wouldn't have got marks. You'll actually get dock marks for mentioning things which are irrelevant, and I say this to my trainees all the time. Okay, so the second question was an essay. So it says, it is an inflexible rule that a court of equity that a person in a fiduciary position is not, unless otherwise expressly provided, entitled to make a profit. He is not allowed to put himself in a position where his interest and his duty conflict. And that is from Bray versus Ford. And then it says, consider, making reference to the relevant case law, whether the above statement accurately represents the position with regards to trustees' duties. And by God, some of the answers I've seen go off on a tangent about trustees' duties in the broad sense, and they did not answer the question, and they probably failed it. So yeah, you can very easily fail a question even though you know a lot of case law. Question 3 was a problem question. David, a businessman, owns a number of properties, and a number of years ago he transferred many of those properties into the name of his niece Claire. He did this in order to protect those properties from the claims of his creditors. Claire was like a daughter to David, who did not have any children of his own. When Claire was a toddler, her parents were killed in a car crash, and he agreed he would assume responsibility for the care of her. He stuck to his word, and they had a great relationship. When he transferred the properties into her name, she was 12 years of age. So this is a trust for a minor, so she is the beneficiary of this trust here. Now, I mean, the fact that he's trying to avoid his creditors, that was the intention, but he also had a good relationship with her, so yeah, we'll see. Since that time, he discharged his debts to his former creditors, but the property have remained in her name. He now has a new business idea where he needs capital and he wants to use it as collateral. In order to get the funding from his bank, he must satisfy his bank manager that he is the beneficial owner. So he's not, Claire is. Unfortunately, when he mentioned this to Claire, it puts a strain in their relationship. She just finished college. She was hoping to sell some of the properties to fund the setting up her own business, and she's insistent that she's entitled to claim the legal ownership of the properties in question. So who's your client here? It's David seeks your advice. So here we have to ask ourselves, is there a trust in the first place? There's an automatic resulting trust, which we know isn't the case here because the beneficial interest is still there. So the other one we have to look at is presumed resulting trust, where the court will draw inferences from the intention of the donor, that it was to be a resulting trust rather than a gift. So that is the question here, is it a trust or a gift? And that's a rebuttable presumption. So where the property is transferred for no consideration, like it was here, a presumption of a resulting trust arises. And this is also seen in section 62 of the LCL R8 2009. Now, as we know, you can defeat the presumed resulting trust by presumption of advancement, i.e. a presumption of trust which suggests the properties transferred between certain categories of people. For example, like a parent-child. So you could say here that they're in a parent-child dynamic. You would argue here that the presumption has not been rebutted, and there's a lot of case law around that. Now, the only thing, and so we have certainty of subject matter, we have certainty of objects. The problem is the intention or the words. So yeah, I mean, you could argue that the intention was to avoid his creditors by putting it into her name. 4 was around Donatio Mortis Causa. I'm not going to go down through it, but it's the typical thing. sorry, this question 4, it's just like, you know, they tell them while they're alive the title deed to the house, and then there's a locked box. That's a very common DMC question. Question 5 was discuss, with reference to case law, the requirement of certainty of objects and one of the other two certainties. I think that was quite nice. Question 6 was an undue influence question. It was quite obvious here. They tried to throw people off a little bit by having it a same-sex couple to see, did you know about the Marriage Act? Question 7 was a notes question, and rectification of a unilateral mistake, Hastings, Bass and Strong v. Bird was asked. And then the long question at the end was your typical proprietary estoppel. Someone was working on a farm and didn't get what was owed to them. So yeah, I hope that enlightens you a little bit. I love answering these questions. And if you're sitting equity this March, best of luck, and don't forget to check out lawhero.eu for any notes. See you in the next one.